Hi, I'm Annie Fitzsimmons. I'm your Washington REALTORS Legal Hotline Lawyer, and this is another episode in our series entitled Operation Evolve. We're going to discuss the meaning of the words as soon as reasonably practical. Those words come into play in this new statute in two regards. You are required to deliver the revised agency law pamphlet as soon as reasonably practical. And you are required to enter a brokerage services agreement with your client, whether your client is a seller or the buyer, as soon as reasonably practical after the provision of real estate brokerage services. So what do the words as soon as reasonably practical mean? Why couldn't the statute have just said, as soon as reasonably practical, but in any event not later than prior to signing an offer to purchase real estate? Well, because if the statute said that, then when would 95% of the brokers have that brokerage services agreement or signed or that agency law pamphlet delivered? They would wait until that last minute and it would be delivered or signed right before the client signs an offer to purchase real estate. That would defeat the goal of the legislature. So what's the goal of the legislature? The goal of the legislature in making this requirement, let's just look for a moment at the signing of the buyer agency agreement. The goal in having the buyer sign a brokerage services agreement with a broker as soon as reasonably practical after the provision of real estate brokerage services begins is to provide upfront a sense of immediacy, if you will, over the disclosure of information to the buyer regarding the compensation a buyer broker is charging in the transaction. Buyer, if you utilize my services, this is what it will cost you. This is when it will be due. This is who's going to pay it. That conversation, the Washington legislature says, must happen soon after the beginning of this relationship between the buyer and the buyer broker. If it happens after the broker has already shown 10 houses to the buyer and maybe even the broker's own listing, where the broker really represents the seller, but the buyer doesn't understand that relationship because it hasn't been explained yet to the buyer, then that's no good. The buyer is left in the dark about those issues that are so important to the buyer in this agency relationship. So instead, the legislature says, the pamphlet has to be delivered and the brokerage services agreement signed as soon as reasonably practical after brokerage services are delivered. So brokers, here's an example. Buyer walks in to your open house. You're holding this open house for the listing broker. You're not the listing broker. Buyer walks in and says, I want to buy this house. Can you write the offer for me? The answer to that question is yes. What does as soon as reasonably practical mean in that instance? Well, there's no way you could have had the buyer sign a buyer agency agreement before they walked in the open house. So as soon as reasonably practical in this instance may in fact mean right before they sign the offer, but really before you start talking to them about the offer terms that they want to make and helping them to negotiate this contract. That's when they should sign the brokerage services agreement. And then you would write the offer. Then they would know exactly what they're going to owe you as their agent, who you represent, the obligations that you owe to them through this relationship. It's all very clear to them. What about a scenario where the buyer doesn't want to buy your open house, but wants to work with you later that week maybe even, to go look at other properties? Do you have to have them sign that brokerage services agreement before they leave the open house? Sure. If you have an opportunity to have a conversation with them then and discuss with them the significance of the brokerage services agreement, but more likely it's going to happen at the very next meeting that you have with them. Not when you're showing them houses, because by the time you're showing them houses, you should already have the brokerage services agreement signed. As soon as reasonably practical doesn't mean after you've already been working with this buyer for 3 or 4 or 5 days showing them homes. It means before you show them the first house. Unless, of course, you meet them at that house. If they call you off of a sign, again, not your listing, but you're holding floor, and you get a sign call in the office. A buyer wants to see a house, and you say, sure, I can meet you over there and show it. Again, you're not going to have a brokerage services agreement with them before you show that house. But before you show them another house, you will. As soon as reasonably practical after the provision of real estate brokerage services. As soon as reasonably practical means immediately, right? As soon, not sooner or later whenever I get around to it, as soon as reasonably practical after the provision of real estate brokerage services. So you're allowed to introduce yourself, let them know what you're going to do for them, give them a bit of consultation about the real estate market. That is the provision of real estate brokerage services when you're consulting with them. And then as soon as possible after that, you're going to have that brokerage services agreement with them. This is going to be the hardest thing that brokers have to grapple with in this revised law. So if you have questions on it or anything else, please ask me a question by visiting WARealtor.org. Thank you for being a Washington REALTORS member.